Kelvin Bales here again from Jackson District Library. Today we have Mark Stanley from Southeastern Dispute Resolution, and he is going to talk about eviction and diversion. So if you got an eviction notice in November of last year, and you haven't got a chance to meet with you and have your pretrial, are you legally allowed to stay in your place that you're being evicted from?
Yeah, the moratorium went through December 31st. I just don't know the specifics on if that's been pushed forward or not. The pandemic's been really hard on landlords. For instance, we had a case that was filed in June. The tenancy was going to end in August, and they didn't have any hearing. There's a moratorium, so the family has been there for another 8 months not paying rent. It hurts everyone. I mean, you have tax issues, you have upkeep, paying your mortgages on your rental property, appreciation issues, you don't know what's being damaged. But then again, the landlord never spoke to the tenant, no communication in 8 months, so they got to talk for an hour and a half yesterday.
On both sides.
Absolutely.
Is there any other, we talked a little bit about landlords as well. Is there any other additional resources available to landlords from the state or federal government where they could not have to go through this process? They could apply for it directly and get it? Or is this basically the only way for landlords to get paid by tenants who have a problem paying?
To be eligible for the assistance, you just have to have a 30-day notice. So you don't have to actually file the eviction to get into the next step. Then again, we don't have any money available right now. So the system's trying to be as equitable as possible to both sides. The community action agencies staff are reaching out to both landlords and the tenants, talking about system and what the eligibility requirements and what the paperwork requirements are. And there's two different ways that the landlords can get their dollars. If they get the 30-day notice and everyone goes to CAA first and everyone files their application and gets the paperwork in and they're accepted into the program, they get a settlement agreement with CAA and they get payment direct, and that was it. And then they just send the court a dismissal. So they could bypass the entire court system. Or they came to the pretrial and we got a conditional dismissal at our stage, or they get a partial agreement because nobody talked to community action agency yet. So the pretrial is their first interaction, and then they start filing the paperwork and they let the court know at their next hearing date. They adjourn the case until the payment's made, and then it's dismissed. So those are kind of the three options. Until we get final notice from MSHDA, we really don't know if there's going to be another option yet. I think there may be some new tax credits and property tax issues popping up for landlords, forgiveness issues. There may be some new pockets of money available for them
when the time comes.
Yeah, because none of this is anybody's fault.
You're absolutely right on that.